Hello everybody, I'm Jana from Sydney Visa. Today we're talking about a PR, Permanent Residency Visa to Australia, that is sponsored by an Australian employer. Specifically, we're talking about the employer nomination theme. It's called ENS or Visa Subclass 186. Those are permanent residency visas, as I said, for skilled workers, right? So they're available for both to the applicants that are already living and working in Australia on their temporary visas, as well as for those who are living outside Australia and have an employer who is willing to nominate them. There are three ways of obtaining those visas. The first one is the temporary residence transition stream. To be eligible, you must have worked for your sponsor for at least 3 years on a temporary visa 482, and you must be nominated by an Australian employer, and this nomination must be approved by the Department of Immigration. The second stream is the direct entry stream, and to be eligible for this stream, you must have one is the positive assessment for in an eligible occupation. Second, you must have English level of minimum equivalent of IELTS or 6, and you also must have an employer that have been approved to provide your nomination. And the third stream is the labour agreement stream. The labour agreements are the formal agreements negotiated between the employer and the Australian government, represented by the Department of Immigration, which lets the employer essentially recruit the skilled workers from outside Australia. Your employer must be a party to such an agreement, either directly or via an industry association, which is the party to the agreement. And this agreement will outline all of the requirements to be met by the visa applicant, right? So including the list of occupation. So the occupation might not, within the agreement, might not be in the skilled occupation list, which is published by the government. The list of all the available agreements, the link to it, I will leave in the description. In all three cases, you must be a professional and your occupation must be on the skilled occupation list. Link to it I'll leave in the description. Nonetheless, the labour agreement, as I mentioned, may grant a concession both for occupation and for some of the main criteria for visas 186. Your sponsor must be in a relevant industry. Thus, for example, an IT company cannot nominate a chef and a restaurant cannot nominate a mechanic. Not every Australian company can nominate a foreign worker. Nominating a position in an Australian company is the most important and the most complex process of this 186 visa program. Therefore, we would like to dwell on it a little greater, so that you have an understanding of what your potential employer will face if he or she decide to sponsor you for the PR visa 186. Before you can apply for visa 186, your employer must submit an application to the immigration department for your nomination and receive a positive decision on your application. So, what kind of effort will be required from your employer to get your DHA nomination approved? Being aware of these efforts during your job search and your potential employer search will make it easier for you to communicate with the potential sponsor. So what are the main criteria for the Australian employer, the sponsor, must meet are as follows. So the business must be operated within Australia. The business must operate in relevant to the occupation that you're applying for industry. The employer must demonstrate that their business has a genuine need to fulfill the specified full-time position. The position must be from the list of eligible occupations specified by the Immigration Department. There must be a contract for the period of minimum of 2 years. The salary must be in accordance with the annual market salary rate, and the employer must make payments to the industry training fund. It's called Skilling Australians Fund, and that sum is ranging between $3,000 to $5,000 depending on the size of the business. Of course, evidence must be supplied to demonstrate that the employer has met the necessary criteria. Some criteria are easier to meet and to prove than others. Usually the most difficult criteria for the employer is to prove these two, so the genuine need for the paid employer and the evidence of the market salary rate. Generally, it is quite difficult for employer to understand the entire nomination and a 186 visa application process. So, in the vast majority of cases, they engage the services of immigration agents. In other words, the process of obtaining a nomination is significantly more complex than a visa application process itself. So, when we immigration lawyers deal with the employer nomination theme, we spend 70 to 80% of our time assisting the employer with the nomination process, and only about 20 to 30% for the actual visa nomination for the potential worker that is coming in. In the description to this video, I will give you all the links to the basic concepts which we're mentioning here in this video, as well as the links to all the work-related visas. In our terminology, work-related visa, we mean those visas that are sponsored by the Australian business. There are only 4 of them. There are 2 that are temporary and 2 that are permanent. The temporary visas are 482 and 494, and the permanent ones are 186, the one we're talking about now, and the other visa is 187. So the main difference between the 186 and 187, which is 187 is regional visa, is that Australian business, so that your sponsor must operate in regional Australia. At the moment, for the purpose of immigration, most of Australia is considered to be regional, with the exception of some of the major cities like Sydney, Melbourne and Brisbane. That's all for now about Visa 186, but I would like to take this opportunity and to clarify a few things about what's called job offer. The job offer should not be confused with the employer sponsorship for this employer nomination theme. Job offer is often necessary for the state or territory nomination, which is one of the stages of the skill migration program, which is visas 190 or 191. Job offer is a confirmation of an intention to employ you if you independently obtain a visa with the right to work. This sort of letter doesn't really create too many obligations for a potential employer and cannot be compared to the complexities and expenses associated with the sponsorship of a foreign candidate. Thus, the reality is that for an immigration candidate, it is 10 times easier should be to get a job offer rather than to get a sponsor. But we will have a video dedicated to this topic separately shortly, so stay tuned. If you have any questions, please ask them here under the video in the comment section. Subscribe to the channel, like the video and share with your friends. Cheers from Down Under.